This courtroom drama starts with pure confidence, a man walking in convinced he knows the law better than the system itself. Facing traffic charges for driving without a license and failing to display it, he doesn't deny what happened. Instead, he tries to redefine it. According to him, he wasn't driving, he was simply traveling. Not a person under the law, but a man. And because of that, he believes the court has no jurisdiction over him. From the very beginning, tension fills the room. He attempts to challenge the case with a motion to dismiss, arguing the court has no authority. But the judge quickly shuts it down, pointing out that the motion wasn't properly filed and didn't follow court rules. Even more surprising, the filing reportedly included biblical references instead of legal arguments. The courtroom atmosphere shifts as it becomes clear this strategy isn't going to work. Still, he refuses to back down. He repeatedly tries to challenge jurisdiction verbally, but the judge calmly explains that motions must be submitted in writing and served correctly. Meanwhile, the officer testifies that the defendant failed to signal, couldn't produce a driver's license or insurance, and had an expired plate. The facts stack up quickly. During cross-examination, the defendant questions why he was detained for so long and why a supervisor wasn't called. Even mentioning that he missed his son's banquet because of the stop. But emotional appeals don't outweigh the evidence. In the end, the judge firmly rejects the constitutional defenses, upholds the violations, and imposes fines for each offense. When the defendant tries to appeal on the spot, he's told to follow proper court procedure. The message is clear: courtroom theories may sound powerful online, but in a real court of law, rules matter. And sovereign-style arguments rarely survive contact with reality.
I've actually already met with Mr. Ramboel before. He was requesting a formal hearing on these two files.
Okay, sounds good. Formal hearings will be set for in-person appearance.
Actually, I filed a motion January 6th is when it went unanswered. I would like the court to dismiss this matter.
Okay, your motion to dismiss is denied.
How many days does the prosecutor have to answer my motion for demand for motion for challenge of jurisdiction that I submitted to the clerk, and I've served everybody, all parties? How long does he have? Because that happened January 6th.
I see it's a motion to show authority.
And also a demand for dismissal, lack of jurisdiction, failure to introduce evidence of an injury in fact, challenges jurisdiction of the court to prosecute. That was filed January 6th.
We only have one motion attached to the file. I don't see the other motions that you're referencing, sir.
It's timestamped by the court. I have it right here.
I see a motion to show authority, which the court has denied. And then there was a memo that was attached. There was not any other motion. I don't read via Zoom.
It's filed with the clerk. Everybody was served.
Mr. Staples, did you get a copy of the motion he's referencing?
I see a copy of the motion to show authority in our file. I don't recognize it as any sort of valid motion or pleadings, but I see a copy of it in our file.
Agreed. That's the same the court has. It's a motion to show authority. The other motions that he's referencing was not properly filed with this court or served as the court. Neither the court nor Mr. Staples' office is in receipt of it. The motion to show authority was denied. Is not in proportion with the Michigan court rules. It does cite, however, Luke 11:46, the King James version, Luke 11:52, as well as some other articles and treaties. But nonetheless, as indicated by Mr. Staples from the Office of City Attorney, this is not a lawful or appropriately filed motion, and for that reason, it was denied before this court. But we will
Well, I
set
like
your
to
matter.
challenge jurisdiction right now. I have the
You
right
can
to
file in a
travel.
Michigan court rules to challenge jurisdiction. But what we won't do is entertain motions under the King James Version of the Bible. Okay?
That was a different motion you're referring to. That was the motion to show authority.
We don't have the other motion, sir. So you can file that motion. It's just we don't have it. I don't know why we only have one motion. That we don't have the other one you're referencing. So you'd have to file that and serve it on the city attorney. We'll give you time to do that. I'm going to set both of these matters for hearing, though.
I can't chill. You telling me I don't have the right to challenge jurisdiction right now? I want to challenge jurisdiction right now.
You can file a motion for challenging the jurisdiction, sir.
I can't do a verbal motion?
No, you cannot.
So you telling me I don't have the right to do a verbal motion?
You don't have a right to do that. You're going to file it in writing and you're going to serve it properly on the parties that you're filing it against. Okay, sir? March 14th at 10:30 in person at the court will be the date for the formal hearing, and then we'll hear any arguments on motions if necessary. You have any questions today, Mr. L? Okay, well, then you're all set. Thank you. Okay, you can have a seat. Thank you.
Officer Vanderwerf, would you state your name for the records, please?
Oh, you want to call him? Let me.
Oh, I'm sorry.
Swear, man, no worries. Vanderwerf, can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, Judge. So I was traveling southbound on King when I observed a pickup truck in front of me that was changing lanes, failing to use its signal. So at that time, I activated my overhead lights on the vehicle to initiate a traffic stop. And then I made contact with the driver, who was later identified as a Rambo L. In our contact, he ended up handing me a piece of paper. At brief glance, when I looked at the piece of paper, it appeared to have what I believe was certain MCL codes that the subject may have typed onto the piece of paper. When I had asked him for a driver's license or identification, he was not really very cooperative. I also don't believe I was provided any insurance. At that time, I decided to issue him a citation for failing to signal, changing lanes, and failing to display a valid license, and then also the license plate through the system was expired.
Mr. L, did you want to question the witness?
Yes. The document that you were referring to, it was a travel document. I was showing you I was traveling versus driving. And I tried to explain that to you. And then you held me on the side of the road for approximately an hour. I requested a supervisor because they might better understand what I was doing, and you never provided that for me. Is that correct?
That's actually incorrect, because the reason that you were held on the stop for as long as you were is because I was waiting for a supervisor. So when I realized the supervisor was not there, I contacted him by phone, at which time he said he was delayed. And when I came back up to the traffic stop, I did ask if you wanted to wait further for a sergeant, and I don't believe that you did. And then you drove off when you were free to go.
Yes. Is it correct that I was held on the road for approximately an hour waiting for this whole encounter to end?
I do not remember if it was an hour specifically, but I do remember that the time length was probably, I would say probably close to that at the very least.
Well, it was an hour, and it caused me to be late for my son's banquet. And and I never got to speak to a supervisor. That's all the questions.
Okay, Mr. L, are you calling witnesses today, or did you want to give your own testimony?
I would like to. I have some. I have a defense. My motion.
Okay, well, you filed a motion?
Yeah, I filed a motion. Served across the
when
city
did you file
attorney.
a motion?
It was filed. It was mailed February 18th.
You filed a motion and mailed it February 18th. Did you serve a copy
to the clerk of the courts and also to the city attorney's office.
Did you receive any motion, sir?
Your Honor, we did receive a motion. It did not have any hearing date stated on it. We had no timetable for a response. I would be happy to respond to the motion on the record orally or provide the court with briefing if they would like.
The court didn't get a copy of the motion in February.
I sent it to the clerk. And,
yeah, typically when that happens, it's just attached to the file. I don't have a copy of any motion.
Oh, well, I did my due diligence. I sent a copy to him. He has his.
Well, I don't know that you did your due diligence because when you file a motion, you got to get a hearing date for that motion. And so
who's supposed to give me a hearing?
You got to get the hearing date from the clerk's office.
From the clerk's office?
Yeah.
So why did they give me one?
Did you contact them for a hearing date?
I contacted them, yeah.
And asked for a hearing date for your motion?
And I asked them when was my hearing. They confirmed that it was today.
For your motion.
And I asked, did I have a hearing date? And they said.
And you do have a hearing date, but that's not what I asked you. Did you ask them, did you have a hearing date for your motion?
For my motion?
Yes.
They didn't tell me, but I did provide to him an order for the motion that gave him 21 days to respond.
Okay, you can make your motion before the court because I don't have a.
Made to the court's jurisdiction hereby moves the court to strike and dismiss the complaint filed by the officer Zinderbarth. Am I pronouncing that right? Sorry if I'm not. For lack of ratification and commencement, no corpus delicti, no plaintiff, lacks jurisdiction, personal or firm jurisdiction. Christina Simmons being appointed as trustee, the prosecutors being appointed as co-trustee, I, Rambo L, an executor and beneficiary of a set of account. Also, I filed a declaration of non-citizenship nationality because I've done a name change. Where my point of authorities are the United States District of Columbia Corporation in Volume 20, Corpus Juris Section 1785. We find United States government as a foreign corporations with respect to the states. Since the corporation is fictitious, it is a fictitious person. It can't see, speak, smell, or touch itself. It's a fictional. Is a fiction in the real world. It needs a conducting, transmitting utility, allegiance, some sort of connection to a fictional person. Constitutional Amendment number 1, Congress shall make no law respecting an establishment of a religion, prohibiting free exercise thereof, abridging freedom of speech or right of press or right of people, peaceful assemble, petition the government for redress of grievance. Number 5, Constitutional Amendment. The right of people should be secure in their person, houses, papers, and effect against unreasonable searches and seizures shall not be violated, and no warrant shall be issued upon probable cause supported by an oath or affirmation, particularly describing the place search of persons things to be seized. And then number 7, Constitutional Amendment, suits at common law where value of controversy exceeding $20, the right of a jury trial shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States according to the rules of common law. I asked for a jury trial, I didn't get that. Rambo L is a man, people, but not a person. I was not operating in commerce, nor was I a driver on the road for travel. A driver is an employee transporting goods or passengers. Rambo was just merely traveling, and in my private seat to say a license is upon a constitutional detention. Motor vehicle means every description of a carrier drawn by mechanical power used in commercial purposes on a highway. There's neither injury nor trespasses. Any trespasses. All crimes are commercial. 27 CFR 72.11, and every alleged crime has to have a nature and cause and be prosecuted by the name of the people of the state. I don't have a contract with the state. I don't see an injured party. I don't know why I'm here.
No. Any additional
I would like the court. I would ask the court to dismiss this to failure to state a claim where relief can be granted.
The court has heard the argument. I'm first address your motion, Mr. L, and I'm going to deny your motion as clearly indicated in the response by the city, your claims would be most appropriately brought before the Court of Claims. And so you can't challenge a constitutional issue in this court, okay? As it relates to the authority and the process to bring this matter before the district court as it relates to your civil infractions, you have an expired plate and a failure to signal. Again, a jurisdiction or venue before this court is appropriate. This is a situation or incident that occurred in the area of South MLK, Martin Luther King Boulevard. That's in the city of Lansing, Ingham County, state of Michigan. And so you're subject to the laws and the ordinances of the city of Lansing, but also the laws under the Michigan compiled laws. Here in this district court, we are subject to the Michigan court rules. And so, although I gave leniency with your motion, it was not properly filed and or served, but it also does not comport with the Michigan compiled laws or Michigan court rules. And so for those reasons, it is denied. Now, as to the civil infraction, failed to signal an expired plate from December 3rd, 2022, we did not provide any valid dispute or defense to these civil infractions. You could have appeared and showed information that demonstrated you did have a valid plate at the time, or that you even have one now, which could reduce the citation, but that's not taking place. And so I'm going to sustain both violations of civil infractions. There's a fine of $125 on each. Okay, sir?
My next defense, am this done or can I say something else?
You can say something else. I asked you if you had any further defense, but you said.
My next defense would be, Michigan allows 72 hours to register any vehicle when it's first purchased. He never asked for anything. I never got a chance to explain myself on the side of the road.
Okay, do you have proof that you had just purchased it within 72 hours?
I don't have the title.
Okay, thank you, sir. If the defense is not meaningful, if you can't provide any evidence to support that defense. That being said, your fine is $125 on each file. When do you intend to make payment?
Do I have a chance to appeal this?
You can.
I would like to appeal.
Okay, you want to file an appeal? It's the civil infraction?
I want to file an appeal today.
Okay, you can file a motion for reconsideration. But you need to follow the Michigan court rules, okay? We don't submit to the sovereign rules, okay?
This courtroom hearing opens with an energy that immediately tells you this is not going to be an ordinary traffic case. A man stands before the judge, charged with driving without a valid license and failing to display it when requested. On paper, it looks simple, routine, almost forgettable. But within moments, it becomes clear that this is going to turn into something much bigger. From the very beginning, the defendant makes it known that he does not recognize the authority of the court in the way most people do. He doesn't start by denying the stop. He doesn't argue that he had a license somewhere at home. Instead, he challenges the very foundation of the case. He insists that he was not driving, he was traveling. He explains that driving, in his view, is a commercial activity, something tied to commerce and contracts. Traveling, on the other hand, is what he claims to have been doing, exercising a constitutional right to move freely. He goes even further. He says he is not a person, as defined under statutory law. He calls himself a man, operating in a private capacity. According to his argument, the laws that apply to persons do not apply to him. It's a semantic strategy, one that hinges entirely on redefining words that courts and legislatures have already clearly defined. The judge listens, calm, patient, professional. There's no visible frustration, no raised voice. Just steady control of the courtroom. The judge asks procedural questions and reviews the filings that were submitted before the hearing. That's when another layer of this case begins to unfold. The defendant had filed a motion to dismiss, arguing that the court lacks jurisdiction. But the motion wasn't filed correctly. It didn't comply with the required court rules. It wasn't properly formatted. It wasn't properly served. And instead of citing controlling case law or statutory authority, it reportedly included unusual references, even biblical passages, as support for dismissing the charges. The judge explains that motions must follow specific rules. There are standards. There are procedures. Courts do not operate on personal interpretations or philosophical beliefs. They operate on established law. Because the motion failed to meet those requirements, it is denied. The defendant immediately pivots. He attempts to raise the same jurisdictional challenge verbally in open court. He repeats that the court must prove jurisdiction over him. He demands that the judge establish authority on the record. But the judge explains that arguments must be presented properly. Motions must be written, filed, and served in accordance with court rules. Verbal assertions are not enough. There's a clear contrast unfolding in the room. On one side, a man relying on a theory that depends heavily on wordplay and self-definition. On the other side, a court grounded in structured procedure and statutory authority. When the prosecution calls the officer to testify, the focus shifts from ideology to facts. The officer calmly describes the traffic stop. The vehicle failed to use a turn signal. That's what initiated the stop. Upon contact, the driver was asked for a driver's license and proof of insurance. According to the officer, neither was provided. The license plate was also expired. The testimony is straightforward. No dramatic exaggeration. No emotional language. Just a recitation of events. During cross-examination, the defendant tries to regain control of the narrative. He questions the officer about the duration of the stop, suggesting he was detained for nearly an hour. He asks why a supervisor was not provided when he requested one. He implies that the stop was excessive and unnecessary. He even brings up the personal impact, explaining that he missed his son's banquet because of the delay. There's an attempt to shift the focus from the violations themselves to the inconvenience and frustration surrounding the stop. But inconvenience does not erase statutory requirements. Missing an event does not transform a traffic stop into a constitutional crisis. As the hearing continues, the defendant circles back repeatedly to jurisdiction. He insists the court is operating under admiralty law. He questions the flag in the courtroom. He suggests that unless the court can prove a contract exists between him and the state, it has no authority. Each time, the judge responds with composure, reiterating that the court has subject matter jurisdiction over traffic violations and personal jurisdiction over individuals charged within its geographic boundaries. There's a moment where it becomes clear that the defendant truly believes in what he's arguing. This isn't sarcasm. It isn't performance. It's conviction. But conviction alone does not substitute for legal precedent. The judge eventually moves toward a ruling. The arguments have been heard. The testimony has been given. The filings have been reviewed. The court explains that traffic laws apply to individuals operating vehicles on public roads. The distinction between driving and traveling, as presented, does not exempt someone from licensing requirements. The statutory definitions are clear. The court's jurisdiction is established by law, not by personal consent. Both violations are sustained. The fines are imposed, $125 for each infraction. Even then, the defendant is not ready to concede. He attempts to file an immediate appeal right there in the courtroom. He announces it as if simply declaring it makes it effective. But the judge explains that appeals must follow proper procedure. There are forms to file, deadlines to meet, rules to follow. Courts do not operate on declarations, they operate on documented process. There's a final exchange that captures the entire tone of the hearing. The defendant continues referencing sovereign principles. The judge responds firmly that the court does not operate under sovereign citizen rules. If he wishes to pursue those theories, he would need to do so elsewhere, not in this courtroom governed by state law. What makes this hearing so compelling is not just the legal outcome. It's the clash of two completely different worldviews. One is built on structured statutes, precedent, and procedural requirements. The other is built on reinterpretation, semantic distinctions, and personal sovereignty. Throughout the entire proceeding, the judge never loses composure. The officer never strays from the facts. The system remains steady, even in the face of persistent challenges. And that steadiness is what ultimately defines the outcome. In the end, the case doesn't collapse under philosophical arguments. It doesn't bend under semantic reinterpretations. It proceeds exactly as the law prescribes. The violations are upheld. The fines are entered. The appeal must follow standard rules. And the courtroom returns to order, unchanged by the theories that attempted to disrupt it.